On March 15, 2022, U.S. President Joe Biden signed into law the EB-5 Reform and Integrity Act of 2022, which makes significant changes to the EB-5 program. One of the most important provisions introduced by the bill is the introduction of reserved visa categories for certain qualifying investments. Reserved visa categories offer an unprecedented opportunity for investors from countries with historically high numbers of EB-5 visa applicants, especially China, to effectively skip the waiting lines for their visas and immigrate to the United States relatively quickly. How investors obtain EB-5 visas. After making an investment in a qualifying U.S. business, an EB-5 visa applicant must submit Form I-526, Immigrant Petition by Alien Investor, to United States Citizenship and Immigration Services, or USCIS. Form I-526 must demonstrate that the investor made an eligible investment. Upon filing Form I-526, the investor receives a priority date, which is the date their petition was filed. If USCIS approves the I-526 petition, the investor is granted a temporary 2-year permanent resident card, commonly called a green card. The investor will later have the opportunity to remove the conditions on his or her green card through Form I-829 and become a permanent resident of the United States. Visa allocation in the EB-5 program. Each fiscal year, the U.S. government allots a limited number of total visas to the EB-5 program, which are then divided amongst individual nations. For example, if 10,000 EB-5 visas are available in a given fiscal year, each nation is allotted 7%, or approximately 700 visas. If the total number of investors and family members from a given nation who apply for EB-5 visas exceeds the 7% per country allotment, visa applicants must wait for visas to become available. This situation is referred to as visa retrogression. Currently, only Chinese EB-5 investors are subject to visa retrogression, but investors from other nations may become subject to retrogression based on high demand for EB-5 visas. The Department of State assigns cutoff dates to EB-5 visa applicants from countries experiencing visa retrogression. These dates are published in a monthly visa bulletin. Cutoff dates are categorized as either filing dates or final action dates. Filing dates determine when an applicant can file to request a visa, and final action dates specify when an applicant can receive a visa. Investors and their family members from countries experiencing visa retrogression may move forward in the visa process only when their I-526 priority dates match or are earlier than the applicable cutoff date. For instance, as of the July 2022 Visa Bulletin, Chinese EB-5 visa applicants have a final action date of November 15, 2015, which means that applicants with priority dates after November 15, 2015 are not eligible for visas. Cutoff dates advance slowly, sometimes taking many months or even years to move forward. The role of reserved visa categories in the EB-5 industry. Only I-526 petitions filed on or after March 15, 2022 are eligible for reserved visas. Investors with earlier I-526 priority dates will not be considered for a reserved visa even if they invested in a TEA project. The EB-5 Reform and Integrity Act of 2022 requires the Department of State to reserve 32% of EB-5 visas each year for investments in targeted employment areas, or TEAs. A location qualifies as a TEA if it is rural or experiences high unemployment. Certain kinds of public infrastructure projects also qualify for TEA status. The 32% of reserved visas can be further categorized as follows: 20% for rural TEA investments, 10% for high unemployment TEA investments, and 2% for investments in public infrastructure projects. If any reserved visas are left unused at the end of the fiscal year, they will carry over in the same category to the following year. The Department of State has made a total of 19,880 EB-5 visas available for the 2022 fiscal year. As of May 2022, few investors have filed Form I-526 since March 15th. Therefore, an estimated 6,362 visas remain reserved for TEA investors and their qualifying family members. Of these available reserved visas, approximately 3,976 visas are reserved for investments in rural TEAs. Approximately 1,988 and 398 visas are reserved for investments in high unemployment and public infrastructure TEAs, respectively. Benefiting from a reserved EB-5 visa. All investors in TEAs who have I-526 priority dates on or after March 15, 2022 are eligible for a reserved visa. Investors from nations with low demand for EB-5 visas are expected to experience slightly faster visa processing relative to normal. The greatest benefit, however, will be felt by investors from countries experiencing or likely to experience visa retrogression. Reserved visas are given priority even if a country is otherwise experiencing visa retrogression. Investors eligible for reserved visas who would typically have to wait for a visa due to retrogression may face a shorter or no delay in EB-5 visa availability. For example, Chinese nationals who invest in TEAs will not have to wait for cutoff dates to advance. In many cases, they may be able to immigrate to the United States years earlier than investors who do not qualify for reserved visas. The number of reserved visas is limited, however, and these categories may fill up quickly. The earlier investors make qualifying investments in TEA projects and file their I-526 petitions, the better the likelihood they will obtain reserved visas for themselves and their families. The reserved visa categories and concurrent filing. The EB-5 Reform and Integrity Act of 2022 also allows investors to file Form I-526 simultaneously with Form I-485. Form I-485 is used by EB-5 investors already living in the United States to adjust their immigration status. These investors often hold non-resident visas such as the H-1B, F-1, E-2, TN, and L-1 categories. Filing the I-526 and I-485 petitions concurrently enables EB-5 investors to adjust their immigration status immediately. As a result, they may enjoy many of the benefits of an EB-5 visa even before obtaining one, which include living, working, and studying anywhere in the United States. Additionally, adjusting status immediately through concurrent filing means that investors will not have to undergo lengthy consular processing in their home countries. Investors who would like more freedom regarding employment opportunities or whose non-resident visas are nearing expiration may be particularly interested in this option. Concurrent filing is not available to investors from countries subject to visa retrogression. The only way for a Chinese investor to benefit from this provision is to invest in a TEA project and become eligible for a reserved visa. If you would like to learn more about the reserved visa categories and available TEA projects, contact EB-5 Affiliate Network today.